Welcome to Ye's Law Journal, the podcast where we explore the intricacies of law and how they shape our world. I'm your host, a digital avatar of Yi, and today we're diving into a topic that's both timely and crucial for anyone involved in competition law and policy. We're talking about the recent judicial interpretations on antitrust law in China. On June 24, 2024, the Supreme People's Court of China released a new judicial interpretation titled Interpretations on Several Issues Concerning the Application of Law in the Trial of Civil Disputes Arising from Monopolistic Conduct. This marks the first major update since 2012, aiming to refine courts' approach to handle antitrust cases and align with recent amendments to China's anti-monopoly law. Let's start with the big picture. Why is this new interpretation significant? Well, it comes just 2 years after the latest amendments to the anti-monopoly law. This interpretation is designed to provide clear guidance for courts, ensuring fair and efficient adjudication of antitrust civil disputes. It's a move towards greater precision and standardization in judicial decisions, helping to enforce the anti-monopoly law more effectively. The interpretation is comprehensive, divided into 6 chapters with a total of 51 articles. They cover everything from procedural rules to market definitions, monopoly agreements, abuse of market dominance, civil liabilities, and more. Compared to the previous version, this new interpretation is more systematic and detailed, offering crucial guidance for both procedural and substantive matters in antitrust litigation. Now let's talk about the procedural changes. One of the key amendments is the establishment of the interest in the suit criterion for determining the admissibility of declaratory judgments. According to Article 2, Paragraph 2, if a plaintiff only requests a declaration that the defendant's behavior constitutes a monopoly without seeking civil liabilities, the court will not accept the case. This aims to prevent the waste of judicial resources and ensure that antitrust litigation serves a substantial purpose. Another important procedural change is the clarification of jurisdiction rules. The interpretation mandates the consolidation of lawsuits arising from the same monopolistic behavior, requiring plaintiffs to file a single lawsuit. This enhances judicial efficiency and consistency, avoiding fragmented cases. Let's shift to the substantive changes. The interpretation introduces several key concepts and standards. For example, it incorporates the notion of a single economic entity and clarifies standards for recognizing horizontal collusion and reverse payment agreements. The interpretation also addresses the dual nature of vertical monopoly agreements, recognizing that they can both promote and restrict competition. It establishes rules for assessing hub and spoke agreements and provides new guidelines for determining market dominance, including presumptive rules for joint dominance. Additionally, it enriches the criteria for identifying various forms of abuse of market dominance, such as unfair pricing, refusal to deal, and tying arrangements. This detailed guidance helps in determining excessive pricing, refusal to deal, and the abuse of intellectual property rights in monopolistic conduct. Moving on to civil liabilities and evidence rules, the interpretation expands on the types of civil liabilities and provides clear references for damage calculations. Plaintiffs can now request the court to order defendants to take necessary actions to restore competition, especially when simply ceasing the monopolistic behavior is not enough. It also refines the rules on the burden of proof and the effectiveness of evidence. The interpretation alleviates the burden on plaintiffs by allowing administrative penalty decisions to serve as presumptive evidence in subsequent civil litigation. Moreover, it specifies conditions under which courts can suspend proceedings if antitrust authorities have already initiated investigations into the alleged monopolistic behavior. Notably, the interpretation addresses specific issues on the internet and intellectual property sectors. For example, it regulates most favored nation clauses in platform agreements, recognizing their potential to constitute horizontal or vertical monopolistic agreements. The interpretation also includes provisions for handling cases where a defendant abuses its dominant position through data and algorithms, reflecting the increasing importance of technology and market competition. To wrap up, the 2024 interpretation by the Supreme People's Court is a significant evolution in China's antitrust judicial framework. It clarifies both procedural and substantive issues and adapts to the complexities of modern market dynamics, particularly in the tech and IP sectors. This comprehensive update aims to enhance the effectiveness of antitrust enforcement, protect market competition, and ultimately benefit consumers. For legal practitioners and businesses operating in China, staying updated on these developments is crucial for compliance and strategic planning. Thanks for tuning in to Yi's Law Journal. Stay tuned for more episodes where we explore the latest in law and policy from around the world. Until next time, I'm Josh, and this is Yi's Law Journal.